My name is Jeff Hart and I'm a lawyer with the Feldstein Family Law Group. Today I will be speaking to you about post-secondary expenses and how much can an adult child be expected to contribute. I know the term adult child seems like an oxymoron, but I will explain shortly what that phrase means. Section 7 of the Federal Child Support Guidelines, often referred to simply as the Guidelines, specifically addresses special or extraordinary expenses such as the cost of post-secondary education, which the basic monthly child support guideline amount does not include. Section 7 of the Guidelines requires that both parents share in these special or extraordinary costs in proportion to their respective incomes after deducting from the expense the contribution, if any, from the child. For example, if the father makes $100,000 per year and the mother makes $50,000 per year, then the father would contribute 2/3 of the cost and the mother would contribute 1/3. Adult children, being over the age of majority but still children insofar as they are still dependent upon their parents, are expected to allocate some funds towards their post-secondary schooling, which is a view well reflected in the case law. Having said this, the first question is how we expect adult children to contribute: through their savings, employment income, scholarships, OSAP, which in case you don't know is short for Ontario Student Assistance Program, other student loans or lines of credit, and most important of all, how much is the adult child expected to contribute? Some parents may argue that the parents should not be obligated to contribute to any post-secondary expenses until all of the child's own resources have been exhausted, which would mean that the child should have obtained the maximum amount of student loans available, spent all of their earnings on their education, and used any savings. This may be considered an extreme position for parents to take, and it is one that is generally not supported in the case law. One approach to take is that if the parents had not separated and were able to afford to pay for the child's post-secondary schooling, would they have done so? Furthermore, would that child have been able to qualify for OSAP given the parents' combined household income? Similarly, a child with separated parents should not be burdened with this cumbersome expense just on account of his or her parents having separated. With regard to OSAP and other student loans, courts in Ontario have stated that parents will not be excused from their obligation to contribute because of the availability to their adult children of student loans. That said, children will often be expected to obtain loans, but courts do not want them to graduate with a crushing debt load if the combined income of the parents was sufficient to prevent them from incurring significant debt occasioned by a loan or loans. Ultimately, the question asked by the courts is, what contribution by the child would be reasonable in the circumstances, having regard to the means of both the parents as well as the child? Of course, the answer to the question will be determined on the facts in each situation and will be case specific. If you would like to speak with one of our lawyers regarding your family law matter, please feel free to contact us at 905-415-1636 to schedule your initial consultation. Thanks for watching.